The third inspection notice arrived on a Tuesday. The previous one had been 3 weeks earlier, the one before that, 3 weeks before that. Each notice gave 24 hours warning and cited the landlord's right to inspect the property. Each time he arrived with a clipboard, walked through every room, photographed things and left without explanation. He said nothing was wrong. He offered no reason for the frequency. I had been a tenant in this property for 8 months. In those 8 months, I had paid rent on time, maintained the property carefully, and caused no problems of any kind. There was no legitimate reason for an inspection every 3 weeks. I looked up the law. A landlord does have a right to inspect rental property, but that right is qualified. Under the implied terms of a residential tenancy, the landlord must give reasonable notice. Typically, 24 hours is accepted as the minimum, and inspections must be carried out at reasonable times. But crucially, the frequency of those inspections must itself be reasonable. There is no legal definition of a specific number of inspections per year. But case law and guidance from organizations including Shelter consistently establishes that monthly or more frequent inspections, absent any specific cause, are likely to constitute a breach of the tenant's right to quiet enjoyment of the property. Quiet enjoyment is a fundamental implied term of every residential tenancy. It means the tenant has the right to use and occupy the property without unreasonable interference from the landlord. Every 3 weeks is unreasonable interference. I wrote to my landlord. My letter was calm and specific. I explained that while I understood he had a right to inspect the property, the frequency of recent inspections, 3 times in 9 weeks, was excessive and constituted a breach of my right to quiet enjoyment. I asked him to confirm that inspections would be reduced to a reasonable frequency and proposed quarterly inspections as standard, with additional inspections by mutual agreement if a specific issue arose. I said that if the inspections continued at their current frequency, I would consider it a continuing breach of my tenancy terms and would seek advice accordingly. He replied that as the property owner, he was entitled to check on his investment. I replied that being the property owner did not override the tenant's statutory right to quiet enjoyment, and that I would be raising a formal complaint with the local council's private rented sector team if the matter was not resolved. The local council, I knew from some research, had enforcement powers in relation to landlords who harass tenants, and excessive, unannounced or over-frequent inspections can constitute harassment under the Protection from Eviction Act 1977. I did not need to contact the council. My landlord's response to my second letter was significantly more cooperative. He said he had been concerned about the condition of the property following some issues with a previous tenant and that he accepted my assurance that everything was being maintained appropriately. He agreed to quarterly inspections going forward. I acknowledged his response in writing and confirmed the quarterly arrangement. There were 2 further inspections during the remaining 16 months of my tenancy. Both were scheduled in advance, both were at convenient times, and both lasted less than 15 minutes. He found nothing to concern him because there was nothing to find. Your landlord has a right to inspect. That right is not unlimited. Frequency, notice, and timing all have to be reasonable. If they are not, you have the right to say so, and the law is on your side when you do. Has a landlord ever exercised their rights in a way that felt more like harassment than a legitimate check? Drop it in the comments. And if you want more complete stories with no part 2s that never come, follow the page. New story every day.